The judge humiliated the lawyer in court, but her response was impressive. Emily Carter had walked into courtrooms many times before, but never had she felt this particular combination of determination and wariness. At 29 years old, she had already built a reputation among a small but loyal group of clients in Boston as a diligent, razor-focused attorney who fought with everything she had. Still, the case scheduled for this Tuesday morning was supposed to be one of the simpler ones on her calendar. A straightforward civil dispute. At least, that was how it had been presented to her. The stakes were not astronomical, but they mattered deeply to her client, Linda Moore, who ran a modest family business that had been in her family for 3 generations. The corporation on the other side was large, polished, and confident, sending a team of well-dressed attorneys to every appearance. Emily was not intimidated by their presence, at least not outwardly. She had spent the past 2 weeks combing through contracts, invoices, and correspondence, preparing her arguments as if she were about to face the highest court in the land. This was her habit. She believed in preparation as much as she believed in justice. When she entered the courtroom, the air was thick with murmurs and the rustle of papers. The scent of polished wood and faint coffee hung in the air. Sunlight streamed in through tall windows, illuminating the long benches filled with spectators, some there for other cases, others perhaps curious about this one. At the center, behind the raised bench, sat Judge Harold Mason. Emily had heard of him long before she stepped into his courtroom. The stories were always the same: sharp-minded, deeply experienced, and famously impatient with lawyers who wasted his time, especially younger ones who, in his eyes, often tried too hard to prove themselves. He was known for cutting through rambling arguments with a few clipped words, and for keeping his docket moving at a brisk, almost punishing pace. Today, his gaze was fixed directly on her as she approached the counsel's table, papers neatly organized in a leather folder. She met that gaze with a calm, professional nod, hiding the flicker of unease it sparked inside her. Linda, seated beside her, leaned in just enough to whisper, "You've got this." Emily gave the faintest of smiles, but her mind was already turning over her opening statements, refining them in her head. She had prepared for counter-arguments, possible objections, and even the chance that a key piece of evidence might be challenged. She had not prepared for the feeling that the judge himself might be an obstacle. The bailiff called the court to order, and the sound echoed through the chamber like a gavel striking metal. Emily stood, straightened her jacket, and began to speak. Her voice was steady, each word measured as she outlined the case. How Linda's business had been overcharged by the corporation for a series of shipments, the clear discrepancies in their billing records, and the harm it had caused to a company that operated on thin margins. She could sense the quiet attention of the room, for now all seemed on track. But as she spoke, she saw the faintest change in Judge Mason's expression, a narrowing of the eyes, a tilt of the head, as if already forming a judgment. Emily pressed on, determined to keep the momentum, yet something in the way he glanced down at his notes made her feel as though she was stepping into a current far stronger than she had anticipated. Her plan was simple: present the facts cleanly, draw the line from contract to violation, and close with a reminder of the fairness her client deserved. She knew her opposing counsel, Richard Blake, was an experienced litigator with a reputation for exploiting hesitation in his opponents. That meant she could afford no slip in her delivery. Yet, even before the first exchange of objections, she sensed the tone of the day shifting. This was not going to be the routine matter she had expected. There was an energy in the room, subtle but undeniable, that suggested the battle ahead would be fought on more fronts than she had planned. She took a measured breath, bracing herself for the challenge that deep down she suspected was coming sooner rather than later. The moment Emily resumed her opening remarks, she barely managed to reach her third sentence before Judge Mason raised a hand, palm outward, his voice cutting through the air with the precision of a blade. "Counselor Carter, before you go any further, I need you to explain to this court why your filing ignored the procedural requirement for exhibits in civil disputes under this jurisdiction's local rule 12.4. The words landed like a cold slap. Emily froze for half a heartbeat, the carefully constructed rhythm of her statement collapsing in an instant. She had reviewed every relevant rule during her preparation, or so she had believed. Now, in front of a courtroom filled with strangers, her competence was being questioned before she had even completed her introduction. A flicker of surprise rippled across a few faces in the gallery. Linda's eyes darted toward her with worry, but Emily quickly straightened her posture, refusing to let the tremor of embarrassment show in her voice. "Your Honor," she began evenly, "the exhibits were filed in accordance with the—" Judge Mason cut her off again, his tone more pointed this time. "Not according to my reading. Perhaps you should revisit the rule before you present yourself as fully prepared in my court." The deliberate sting in his words was undeniable. He leaned back slightly in his chair, watching her with an expression that straddled skepticism and mild amusement. From the other side of the courtroom, Richard Blake lowered his head to his papers, but Emily caught the faint curve of his mouth, the kind of smile that was never meant to be kind. She recognized it instantly. She had seen it in more seasoned attorneys who believed they had already won before the battle began. Emily took a breath, drawing on every ounce of discipline she had learned in her early years. "If it pleases the court, I will address the procedural point in my written brief at the conclusion of today's hearing. May I proceed with the facts?" Her tone was respectful, but anchored in quiet firmness. Judge Mason gave a curt nod, but the damage had been done. The interruption had shattered the steady momentum she had built, and the audience seemed to be studying her now not as a capable advocate, but as someone under suspicion of incompetence. She could feel the weight of their unspoken questions. Was she in over her head? Would she falter again? She forced herself to continue, reintroducing the central narrative of the case, but Mason's first blow had altered the entire atmosphere. Each sentence now felt like she was climbing uphill against invisible resistance. Linda sat still, her hands folded tightly in her lap, eyes fixed on Emily as if willing her to push through. The judge's interjection lingered in her mind, even as she spoke. She knew every moment from this point forward would be under a microscope. Any slip in detail, any hesitation, would confirm whatever suspicion had just formed in his mind. She kept her tone measured, refusing to speed up or let her frustration creep into her words. At one point, as she outlined the sequence of overcharges, Mason interrupted again, not to challenge her facts, but to clarify them in his own words, as though to demonstrate a more concise delivery. His phrasing carried a subtle edge, and Emily understood that the exchange was not merely about efficiency, it was about control. In his courtroom, every word she spoke was subject to his approval or correction. She adjusted quickly, trimming her explanations without sacrificing clarity, knowing that over-defending herself would only worsen the situation. It was a delicate dance. Assert her case, maintain credibility, and avoid giving him another opening to undermine her in front of the audience, or worse, in front of Linda. Despite her careful navigation, she caught more sidelong glances between spectators. Even the court reporter, her fingers flying over the stenograph, seemed to register the unspoken drama unfolding between the bench and the young attorney at the podium. The contrast was stark. Richard Blake sat unruffled, his notes neatly stacked, occasionally leaning back as though simply waiting for the inevitable moment when the judge's patience with her would expire. Emily closed her opening by reiterating the harm suffered by Linda's business, careful not to let her voice betray the pressure she was under. When she finally stepped back, the silence felt heavier than before. Mason regarded her for a moment, then looked toward Blake, signaling that the floor was his. As she returned to her seat, Emily felt the faint warmth of Linda's hand on her arm, a quiet show of solidarity. She gave a small nod in return, but her mind was already replaying the exchange with Mason. The first blow had landed hard, not just in the courtroom's perception of her, but in her own awareness of how this day might unfold. This was no longer a routine case. It was an unspoken test, and she understood with perfect clarity that the judge's eyes would not leave her for the rest of the hearing. If she was going to win this, she would need more than preparation. She would need the resilience to absorb each strike and still stand taller with every word she spoke. The courtroom had a strange way of magnifying the smallest gestures. A raised eyebrow, the faintest smirk, the sound of someone shifting on a wooden bench. All of it seemed amplified when tension filled the air. Emily Carter sat at the counsel's table, her papers aligned in precise stacks, but her mind was far from orderly. Judge Mason's repeated interruptions were beginning to carve at the edges of her composure. It wasn't just that he questioned her, it was the way he did it. Each time, his voice carried the unshakable authority of a man who had sat on the bench for decades and believed he had seen every possible mistake a lawyer could make. The pauses he left afterward were equally deliberate, hanging in the air as though to allow everyone in the room a moment to register the subtle implication. Perhaps she was out of her depth. Across from her, Richard Blake wore that same composed expression, but his eyes told a different story. They held the kind of satisfaction that came from watching an opponent struggle, even if only slightly. The corner of his mouth twitched now and then, not enough to be called unprofessional, but just enough for Emily to know he was savoring the imbalance. She shuffled her notes, more to keep her hands busy than out of necessity. Her fingers brushed the edges of legal pads filled with her handwriting. Every clause of the contract, every figure from the invoices, every detail that might give Linda Moore a fighting chance. And yet, in the space between one interruption and the next, a thought she hadn't felt in years whispered at the back of her mind. Maybe I am not good enough for this. The whisper was dangerous. She had worked too long and too hard to allow it to grow roots. But Judge Mason's steady, unblinking gaze had a way of drawing it out, making her feel like the law school graduate who had once been terrified to speak in front of a full lecture hall. She pressed her tongue to the roof of her mouth and kept her breathing slow, knowing that if she let the doubt take hold, her voice might betray her. Linda's presence beside her was both a comfort and a pressure. Emily caught sight of her client's clasped hands resting on the table, the knuckles white from how tightly she held them. When Emily met her eyes, there was no judgment there, only a quiet, desperate plea for someone to fight back. That look was a spark, and sparks had saved Emily before. The proceedings dragged forward, each exchange feeling longer than the last. Emily tried to reclaim control by choosing her words more carefully, speaking only in crisp, fully formed sentences that left as little room as possible for interruption. Still, Mason found ways to rephrase her points, as though they were incomplete without his refinement. He would lean forward, rest his elbows on the bench, and deliver the same argument in a tone that suggested it had just now been made correctly. Emily knew that to object to this treatment outright would be a tactical mistake. Judges were human, and egos were fragile. Instead, she adapted. Each time he restated her point, she would simply nod and continue, slipping in an extra detail he had left out. It was an exhausting strategy, like trying to build a wall while someone else rearranged the bricks as she worked. Through it all, Richard Blake seemed to take meticulous notes, though she suspected half of what he was writing were reminders to press on her perceived weaknesses later. He was the type to store ammunition quietly, only to fire it when it could do the most damage. Emily had seen lawyers like him win cases not through the strength of their arguments, but by wearing down the person on the other side until they began to make mistakes of their own. There was a moment, just before the midday recess, when Emily's voice faltered, barely noticeable but enough for her to feel it in her chest. Mason had once again interrupted, this time to correct a date she had mentioned, claiming it did not match the court's record. She knew she was right, but arguing would risk further antagonizing him. Instead, she offered a measured acknowledgement and moved on. But inside, her confidence took another small step back. As the bailiff announced the recess, Emily sat in her chair longer than necessary, letting the room empty around her. She stared at the neat lines of her handwriting on the legal pad, the ink unshaken by the morning's events, and wondered how much of the trial was truly about facts and how much was about perception. In this room, at this moment, perception felt like the heavier force. Linda leaned in, her voice low but firm. "You're doing fine. Don't let him rattle you." It wasn't a grand speech, but the sincerity in her tone was enough to remind Emily of why she was here. She wasn't fighting for her own pride, though that mattered too, but for a woman who had been wronged and needed someone willing to withstand the blows on her behalf. By the time the judge returned, Emily had rebuilt a fraction of her steadiness. The doubt was still there, coiled in the corner of her thoughts, but it no longer owned the space entirely. If Mason wanted to test her, then she would endure the test. And if Blake wanted to wait for her to falter, he might have a much longer wait than he expected. What she did not yet know was that the trial's next obstacle would not come from a sharp word or a mocking glance, but from a procedural decision that could strip away one of her strongest weapons in the fight ahead. The afternoon session began with a subtle but palpable change in the atmosphere. The room felt slightly warmer, the air heavier, as if the day itself had grown tired. Emily Carter returned to the lectern with a renewed determination, ready to introduce the piece of evidence she believed could anchor her entire argument. The invoice sat near the top of her folder, printed on crisp paper, the numbers neatly aligned, each discrepancy highlighted in faint yellow. She had rehearsed the presentation of this document in her mind countless times. It was straightforward, clear, and nearly impossible to dispute. At least, that was what she believed when she first prepared it. She began by setting the stage, outlining the timeline of transactions between Linda Moore's business and the defendant corporation, the agreements under which the shipments were made, and the financial strain caused by the inflated charges. Her voice was steady, the cadence of her words carefully measured. Then, with a deliberate gesture, she reached for the invoice, holding it up slightly so the judge could see. "Your Honor," she said, "this document shows the precise overcharges billed to my client over the past fiscal quarter. The amounts, dates, and services listed here directly contradict the defendant's own financial disclosures." She stepped forward to hand it to the bailiff, who in turn carried it toward Judge Mason. Before the judge even glanced at it, Richard Blake was on his feet. "Objection, Your Honor," he said smoothly. "This exhibit has not been properly authenticated according to the rules of evidence. Furthermore, it appears to be a reproduction rather than an original record, which raises questions about its integrity." His voice carried the kind of confidence that suggested he had been waiting for this moment. Emily was ready for objections, but she had not expected such an immediate and forceful attempt to disqualify the invoice entirely. She began to respond. "Your Honor, the document has been verified through—" Mason raised his hand, cutting her short. "Counselor Carter, before I even consider this, tell me where the original document is and why it was not submitted in accordance with procedural standards." Emily explained that the original invoice had been kept in digital form by the corporation itself, and the copy she provided was a direct printout from their own records obtained during discovery. She emphasized that the opposing side had never disputed its authenticity in pre-trial discussions. The judge's expression did not soften. "That may be so, but without the original or a properly certified copy, this document cannot be admitted as evidence." Objection sustained. His gavel struck once, the sound echoing across the room. The words hit Emily with more force than she expected. This invoice had been the backbone of her strategy, the undeniable proof that could slice through layers of corporate obfuscation. Without it, her case suddenly felt as though one of its main supports had been kicked out from under her. She knew there were other pieces of evidence, other angles to argue, but none had the clean, irrefutable impact of that single sheet of paper. She returned to the counsel's table, her mind racing. Linda leaned closer, her whisper urgent. "What does that mean? Can't you use it at all?" Emily kept her gaze forward as she replied quietly, "Not unless the judge changes his ruling, and that's not likely." She could feel the heat rising in her chest, not from anger alone, but from the weight of knowing the jurist in front of her had the power to decide which tools she could and could not wield. Richard Blake settled back into his seat with a calm, almost content expression, as though this outcome had been inevitable from the start. He shuffled his papers slowly, each movement deliberate, making no effort to hide his satisfaction. Emily had no doubt that he had anticipated her reliance on the invoice and had prepared to strike it down at the first opportunity. As the proceedings continued, she forced herself to adapt, redirecting her argument toward other aspects of the case. But the absence of the invoice was a void she could not ignore. Every time she referenced the overcharges, she could sense the absence of that solid piece of proof, a silence where a definitive statement should have been. She had to rely more heavily on witness testimony and the less direct evidence buried in the contract's wording, which she knew would be a harder sell to a judge who valued precision and procedural perfection. The rest of the afternoon passed in a blur of objections, counter-arguments, and the relentless push and pull of courtroom strategy. Yet through it all, the loss of the invoice weighed on her like a stone. She could see it in Linda's posture too, the slight slump of her shoulders, the way her gaze drifted down to her hands. When the judge called for a short recess before the final segment of the day, Emily stayed seated, staring at the notes in front of her without really seeing them. She could not afford to dwell on the setback, but her mind kept circling back to the same question. Without that document, what was her clearest path to winning? The answer would not come from stewing over what she had lost. It would have to come from finding something new, something hidden, something the defense had overlooked. The kind of detail that, once uncovered, could shift the balance again. Emily knew she had to find it, and soon. The hum of whispered conversations filled the courtroom during the recess, a soft background noise that seemed to pull Emily deeper into her thoughts. She sat motionless at the counsel's table, her gaze fixed on the folder before her. The invoice's exclusion had left an undeniable void in her strategy, but she refused to let that defeat settle into permanence. She told herself over and over that the law often rewarded those who adapted quickly, those who could find an opening even when the door they'd been aiming for was slammed shut. She pulled the corporation's contract toward her, the document thick with clauses, subclauses, and technical language that seemed designed to exhaust anyone who dared read it closely. She'd already studied it dozens of times, highlighting the sections that supported her argument and scribbling notes in the margins. Yet now she turned to it with a different kind of focus, searching not for what she already knew, but for what she might have missed. Page after page, her eyes moved over the small type. She traced the words with the tip of her pen, almost as if following a trail. She paused at one section, scanning it again. It was buried deep in the latter half of the contract, nestled between two dense paragraphs on pricing adjustments and delivery schedules. At first glance, it appeared routine, a simple provision outlining how disputes over billing should be resolved. But something about the wording struck her as inconsistent with the rest of the document. She read it again, slower this time. The clause stated that any billing disputes must be resolved in strict accordance with the rates and calculation methods set forth in Schedule C, without deviation or supplemental charges not expressly agreed upon in writing. Her pen stopped moving. This was it. This was the overlooked detail. She quickly flipped back to Schedule C, a small table attached at the end of the contract. The rates listed there were significantly lower than the amounts the corporation had charged Linda's business, numbers that lined up precisely with the overcharges she had been trying to prove through the excluded invoice. The invoice might be gone, but the contract itself was still admissible evidence, and the clause's wording, paired with the schedule, created a direct contradiction to the corporation's defense. A surge of cautious optimism ran through her. It was not as strong as the clear, visual proof the invoice would have provided, but it was something solid, something that even Judge Mason might have to acknowledge. She circled the clause in red ink, then drew a line to Schedule C, marking the relevant figures. She began jotting quick notes on how to present it in a way that would not only survive objections, but make the absence of the invoice irrelevant. Linda leaned closer, her voice low but curious. "What is it?" Emily turned the document slightly toward her. A clause they probably thought no one would pay attention to, but it undercuts their entire position. Linda's eyes widened, a flicker of hope breaking through her earlier frustration. "Can it help us?" "It's not just helpful," Emily said, keeping her voice steady. "It's the kind of thing that can shift the ground under their argument if I use it right." She spent the remaining minutes of recess refining her plan. The key would be framing the clause as central to the case rather than as an afterthought. If she presented it with enough authority and precision, Richard Blake would have no choice but to respond to it directly, and Judge Mason would be forced to weigh its implications against the corporation's defense. When the bailiff called the court back to order, Emily felt a flicker of the confidence that had carried her into the courtroom that morning. She placed the marked contract on top of her notes and rose to her feet. This was not the path she had planned to take, but it might be the path that would lead them forward. Richard Blake, noticing her movement, glanced up with a wary look, as though sensing a change in her demeanor. His expression remained calm, but there was the slightest narrowing of his eyes, a silent acknowledgement that perhaps she had found something. As she stepped toward the lectern, Emily thought about how cases often turned on the smallest of details, the overlooked lines buried in fine print. The corporation's attorneys had surely reviewed this contract many times, but they had likely dismissed this clause as boilerplate language. That oversight might soon become their undoing. Her fingers brushed over the red-circled words once more as she prepared to speak. The absence of the invoice still stung, but now she had a new weapon. One that, if wielded carefully, could slice through the corporate facade just as sharply. What remained to be seen was whether Judge Mason would allow her the space to use it. The courtroom settled into a quieter rhythm, as Emily rose to address the court again, the contract in her hand like a carefully chosen blade. She approached the lectern with deliberate composure, setting the document down before her and meeting Judge Mason's gaze. There was no hesitation in her voice as she began, framing the fine print clause not as a minor technicality, but as a central pillar of the dispute. Your Honor, while the court has ruled that the disputed invoice cannot be admitted, the contract itself contains terms that speak directly to the billing practices in question. Specifically, Section 12, Paragraph 4, states that all charges must adhere to the rates in Schedule C without any deviations not expressly agreed upon in writing. She paused, letting the language settle over the room before continuing. Schedule C shows rates that differ substantially from the amounts the defendant billed to my client. She could almost feel the shift in the air, the subtle tension that comes when a point begins to take shape. But before she could elaborate, Richard Blake rose from his seat with the ease of someone stepping into a dance he had practiced many times. "Objection, Your Honor," he said smoothly. "This is a transparent attempt to reintroduce excluded evidence through the back door. The plaintiff's counsel is clearly referencing figures from the disallowed invoice, and as such, this line of argument is both irrelevant and prejudicial." Emily kept her expression neutral, but inside she felt the familiar spark of frustration. Blake was quick, always moving to strike before an idea could gain traction. She turned slightly toward the judge. "Your Honor, my argument stands entirely on the language of the contract, which is already in evidence. The figures in Schedule C speak for themselves, and my client's case does not require the excluded invoice to establish that overcharges occurred. The defendant's own agreement limits them to the listed rates." Mason's eyes narrowed, not in outright disapproval, but in evaluation. "Mr. Blake, the contract is indeed part of the record," he said, his tone measured. "However, I will hear your argument as to why this provision should be disregarded." Blake adjusted his tie and stepped forward, his voice firm. "Your Honor, boilerplate clauses like this are not uncommon in service agreements, and they often conflict with subsequent negotiated terms. Without the corresponding documents showing how the parties agreed to adjust these rates, which plaintiff's counsel has not produced, this clause is meaningless. Furthermore, relying on it now is a calculated tactic to sidestep the court's earlier ruling." Emily felt the eyes of the room on her, the unspoken question of whether she could weather the attack. She straightened her shoulders and responded before Mason could close the matter. "Your Honor, the defense has presented no evidence of any amendments to this contract. If such negotiated changes existed, they would have been produced during discovery. In the absence of those changes, the original terms control. Ignoring this clause would be ignoring the agreement both parties signed." A silence stretched between the two attorneys, the kind that often decided whether a point survived or died in court. Mason tapped the gavel lightly, not in judgment but in thought. His gaze moved from the contract to Blake, then to Emily, weighing not just the words, but the authority with which they were delivered. Finally, he spoke. "The objection is noted. I will allow the plaintiff to proceed with her argument, but I warn both counsel that I will not tolerate attempts to reframe excluded evidence as admissible material. Ms. Carter, keep your focus strictly on the contractual language." Emily inclined her head, careful to keep her relief invisible. "Understood, Your Honor." She returned to her explanation, dissecting the clause with the precision of someone assembling a complex puzzle. She spoke slowly enough for each piece to land, but without giving Blake room to interrupt again. She laid out how the rates in Schedule C aligned with the payments Linda's business should have made, contrasted against the amounts actually charged. She framed it as a straightforward contractual violation, simple enough for anyone in the room to follow, but layered with enough legal substance to stand up under scrutiny. Blake's pen scratched across his notepad, though Emily suspected it was less about taking notes and more about projecting an image of control. Yet she caught the slight tension in his posture, the faint rigidity in his jaw. He was listening closely, perhaps more closely than he wanted anyone to notice. By the time she finished, the room had grown quiet again. Mason gave no indication of his thoughts, but Emily could see that the argument had landed somewhere in his mind. Whether it would influence his eventual ruling was another matter. But for now, she had survived the pushback and kept her footing. As she returned to her seat, Linda glanced at her with a look that mixed relief and cautious optimism. Emily gave a small nod, silently assuring her that this was far from over. If anything, the resistance she faced only confirmed that she was pressing on a point worth fighting for. Emily remained standing at the lectern for a moment after the judge's ruling, feeling the faint vibration of adrenaline under her skin. The courtroom was still, all eyes fixed on her, and she knew that lingering silence could work in her favor. Slowly, she placed her fingertips on the edge of the lectern, grounding herself in the smooth wood before speaking again. "Your Honor," she began, her tone calm but deliberate, "the clause I've referenced is not an incidental provision. It is a fundamental term governing the financial obligations of both parties. The rates in Schedule C are not suggestions, they are binding figures, expressly agreed upon and unaltered by any amendment or side agreement." She let her eyes sweep across the room, not lingering on Blake, but making sure the jurors, the court reporter, and even the gallery could hear every word as if she was speaking to them directly. "If the defendant charged my client more than these listed amounts without written authorization, then they breached this contract. And under the law, a breach is not just a technical error, it is a violation that demands remedy." There was a measured confidence in her voice now, one that hadn't been as strong earlier in the day. The earlier interruptions, the exclusion of the invoice, and Blake's immediate objection had each pushed against her. But instead of buckling under that pressure, she was letting it fuel her delivery. Blake sat back in his chair, his expression unreadable, but Emily sensed a flicker of annoyance in the way he tapped his pen once against the table. It was subtle, but in the language of courtroom tells, it was a small crack in his otherwise polished composure. Emily continued, shifting her tone to something more accessible, ensuring that even those without legal training could follow the logic. Imagine a customer walking into a store with a price list posted clearly on the wall. The customer agrees to buy the goods at that listed price. Later, they receive a bill charging them 20% more than the posted rate without any explanation or agreement. That's not a misunderstanding. That's a breach of trust and of contract. A few murmurs from the gallery broke the otherwise steady quiet. Emily kept her gaze forward, resisting the temptation to look for their reactions. She knew better than to appear as though she were performing for the audience. This was about persuasion, not spectacle. Judge Mason's eyes were steady on her, his hands resting on the bench. He gave no sign of whether her analogy had moved him, but he didn't interrupt either, and that alone was a small victory. She pressed on. "The defense may claim that subsequent agreements altered these rates," she said, "but they have presented no such agreements. They have produced no signed amendments, no written approvals, and no correspondence indicating that my client consented to higher charges. Without those, the original contract governs, and it is clear, unequivocal, and binding." She paused again, letting the weight of her words hang in the air. She knew Blake would respond soon, likely with a rehearsed argument designed to frame her point as naive or incomplete. But she was ready for that. The key was to keep her voice steady, her reasoning tight, and her body language controlled. When she returned to her seat, Linda glanced at her, the lines of worry around her mouth easing slightly. "That was good," she whispered. Emily nodded once, not breaking her focus. "It's not over. He's going to hit back." And hit back he did. Blake rose smoothly, his tone measured but with an undercurrent of condescension that only another attorney would recognize. "Your Honor, what opposing counsel fails to acknowledge is that commercial relationships often evolve in ways that the original documents cannot fully capture. Oral agreements, course of dealing adjustments, and even customary business practices can effectively alter the strict terms of a written contract. The plaintiff's insistence on this clause ignores the realities of business operations." Emily knew this was where lesser attorneys might take the bait, diving into a heated rebuttal, but she held back, allowing the judge to digest Blake's argument. Mason asked no immediate follow-up questions, instead gesturing for Blake to continue. "Furthermore," Blake said, "the plaintiff's reliance on Schedule C is misleading. The rates listed there are baseline figures, not final charges. Additional fees and surcharges are common in this industry, and my client acted in accordance with those standards." When he finished, Emily rose without hesitation. "Your Honor, the defense's position essentially asks this court to accept that unwritten, unproven adjustments should override the clear signed agreement both parties entered into. That is not law. That is speculation. and speculation cannot erase a breach. The exchange left the room quieter than before. The jurors shifted in their seats, some glancing briefly at one another. Blake returned to his seat with deliberate calm, but Emily noticed the way he avoided meeting her eyes. That told her enough. In that moment, she felt something unfamiliar for the day, a sliver of momentum tipping her way. She wasn't out of danger, not by any measure, but she had weathered another round and was still standing. The pressure that had threatened to crush her earlier was now driving her forward, sharpening her focus with every word she spoke. The faint hum of the ceiling fan was the only sound in the room for several seconds after Emily returned to her seat. She could feel the heat of the courtroom lights on the back of her neck, though she knew they were no brighter than usual. It was the pressure, the invisible weight of expectation, that made every movement and every breath feel heavier. She had just managed to hold her ground against Blake's last attack, but she could sense that the next strike would come fast and aim directly at the heart of her argument. Judge Mason adjusted his glasses and leaned forward slightly, fixing his gaze on her. "Ms. Carter," he said, his voice even but carrying an unmistakable edge, "can you provide precedent, binding or persuasive, that supports your interpretation of this clause as grounds for a breach of contract claim without the supporting invoice?" The question was both a challenge and a trap. Without precedent, her carefully constructed reasoning could crumble under its own weight. With weak precedent, she risked the judge dismissing her argument as speculative. She swallowed once, buying herself a single second of thought. She had anticipated the possibility of legal precedent coming into play, but she hadn't expected it to be framed so directly, so suddenly, and under the watch of a judge whose patience seemed measured in seconds rather than minutes. "I can, Your Honor," she said carefully, already flipping through her notes. Her fingers moved with the efficiency of muscle memory, turning past the pages marked for opening arguments and into the smaller section she kept for potential legal citations. There it was, case number 2011-472, Harrington Supply vs. Eastland Freight Co., a commercial dispute that, while obscure, mirrored Linda's situation almost perfectly. But before she could speak, Mason continued, "I'll give you 2 minutes to make your point, not a second longer. Proceed." Her heart picked up speed, but her voice stayed level. In Harrington Supply vs. Eastland Freight Co., the court ruled in favor of the plaintiff based solely on the defendant's deviation from agreed-upon rates in the written contract. No supporting invoices were admitted into evidence, yet the court found that the contract's express terms were sufficient to prove breach, as the defendant failed to show any signed amendments or modifications. She could see Mason listening, though his expression remained unreadable. She pressed forward, outlining how that ruling established that a contract's own language, when clear and unambiguous, could serve as the primary evidence of a breach in the absence of secondary documentation. "The similarity lies in the fact that my client's contract contains an explicit rate schedule, and the defense has failed to produce any binding alteration to those rates. This aligns with the precedent in Harrington, where the court held that the original agreement prevails when no valid modification exists." She checked the judge's posture, searching for any sign that her words were landing. Mason gave a slight nod, nothing more, but he did not interrupt her. That alone kept her going. Blake, however, was ready. He rose before she had even stepped back. "Your Honor, I must point out that Harrington was decided in a different jurisdiction and under statutory provisions not directly applicable here. Furthermore, in that case, the surrounding evidence, though not admitted, was substantially undisputed. In our case, the charges themselves are in dispute, and the absence of admissible supporting documents makes any comparison tenuous at best." Emily countered quickly, unwilling to let his framing take root. "While Harrington may not be binding in this jurisdiction, it is persuasive and the core principle is directly relevant. A clear and enforceable contract term is not nullified simply because the breaching party claims an unproven adjustment. Without written evidence of such an adjustment, the original rate remains controlling. The logic of that ruling transcends jurisdictional boundaries." The judge raised a hand, signaling for both to stop. "I've heard enough on this point," he said. "The court will take the cited precedent under consideration." Emily exhaled slowly, careful to keep the release of tension invisible. She had met the 2-minute challenge, kept her footing, and left the argument in the judge's hands. Yet she knew that the moment had been far too close for comfort. One slip in her recall, one hesitation in her delivery, and the precedent might never have reached the record. As the session continued, she found her focus narrowing, her mind filtering out every distraction except the cadence of the proceedings and the next possible challenge. The margin for error had shrunk to almost nothing, and she could feel herself walking a tightrope suspended between victory and collapse. Linda leaned toward her during a brief pause. "You were quick with that case. I don't know how you remembered it so fast." Emily gave the faintest smile, though her eyes remained on the bench. "Because I knew he'd ask for it, just not like that." She didn't add what she was thinking, that next time she might not be as lucky. The judge's question had been more than a request for precedent. It had been a deliberate test, a way of seeing whether she could think on her feet under extreme pressure. And if she had failed it, the entire foundation of her case could have started to unravel before the day was done. The tension in the courtroom was thick enough to feel in the chest. Emily stood at the lectern, her notes spread before her like pieces of an intricate map. She knew that this next stretch would decide whether her argument gained a firm foothold or slipped into obscurity. She had one chance to weave the contractual clause, the figures in Schedule C, and the precedent she had just defended into a coherent and irrefutable narrative. "Your Honor," she began, her tone steady, but carrying a deliberate undertone of urgency, "the issue before the court is not complex in its essence. It is about whether a written, signed agreement can be disregarded in favor of unsubstantiated claims of altered terms. The defendant has suggested that changes to the agreed-upon rates were understood or customary, yet they have provided no signed documentation, no verified correspondence, and no credible testimony to support that position. The contract is the highest expression of the parties' agreement, and it is binding in its plain language." She took a small step forward, resting her hand lightly on the open contract. Section 12, paragraph 4, requires that all charges align with Schedule C unless explicitly modified in writing. That requirement is not ambiguous. It is absolute. Schedule C, entered into evidence, sets forth the agreed rates. The defendant's invoices, even though excluded, correspond exactly with the overcharges when compared to those rates. In other words, the breach exists within the four corners of this contract. Mason leaned back slightly, watching her without interruption. That was encouraging. Silence often meant he was weighing the argument rather than dismissing it outright. Emily turned her attention momentarily toward the jurors, careful not to linger too long. When two parties sign a contract, they agree to be bound by what it says, not by what one of them later claims it should have said, or by what they wish they had negotiated. If the defendant wanted to charge more than the rates in Schedule C, they were obligated to secure my client's written consent. They did not. That omission is not just a procedural oversight. It is a fundamental violation of the agreement. From the corner of her vision, she caught Blake adjusting his chair. His posture was as straight as ever, but she could sense the subtle shift. He was preparing a counterpoint, but perhaps with less ease than before. She moved to connect her legal foundation with the precedent she had cited earlier. In Harrington Supply versus Eastland Freight Commerce, the court recognized that when a contract clearly defines pricing terms and the breaching party cannot show valid modification, the original terms prevail. The defense here faces the same problem as the losing party in Harrington. They cannot point to a single signed document that supports their claim of altered rates. Without that, the rates in Schedule C are not just relevant, they are determinative. There was no flicker of impatience from Mason yet, so she pressed forward, drawing the threads together. Taken together, we have three undeniable points. First, the written contract contains unambiguous pricing terms. Second, the defendant has admitted through their own testimony that they charged rates higher than those listed. And third, they have no documented signed modification to justify doing so. This combination is more than sufficient to establish breach without the need for any supplemental evidence. A stillness settled over the room, the kind that came when arguments began to click into place. Even the court reporter seemed to slow slightly, as though listening more closely. Blake rose to challenge her, his voice carrying a measured caution. "Your Honor, my learned colleague oversimplifies the matter. While she insists on the primacy of the contract's original terms, The reality is that business dealings often evolve. It is not uncommon for parties to operate under an informal understanding that supplements written agreements, particularly in industries where flexibility is key. My client acted within those accepted practices, Emily responded, without waiting for Mason's invitation. Accepted practice does not supersede a signed contract unless both parties agree to it in writing. If informal understandings could override explicit terms, the stability and reliability of contracts would vanish. That is precisely why courts across jurisdictions have upheld written terms when no valid modification exists. Mason's gaze shifted from one attorney to the other. His expression revealed nothing, but the fact that he allowed her to speak without cutting her off gave her a rare sliver of confidence. She returned to her seat with deliberate calm, stacking her notes in precise alignment. Linda, still tense beside her, whispered, "That sounded strong, like you tied everything together." "I had to," Emily murmured back, her eyes still on the bench. "It's the only way to keep this argument alive." She knew the day was far from over, and that Blake would look for any remaining crack to pry open. But for now, she had done what she needed. She had connected the dots in a way that not only made sense, but made dismissal far more difficult. Whether Mason would accept that picture was a decision only he could make. The courtroom seemed to grow smaller as the afternoon wore on, the walls pressing in under the weight of the arguments that had already been exchanged. Emily knew she had gained some ground with her last presentation, but she also understood that victories in a trial were rarely permanent. Each point won was followed by a counter-strike, and the next was already on its way. Richard Blake stood with the same measured confidence he had displayed all day, but there was a sharpness to his movements now, a slight quickness in the way he adjusted his jacket before stepping to the lectern. In his hands was a thick stack of documents, neatly clipped and tabbed. He laid them on the surface with deliberate care, making sure everyone could see the weight of what he was about to present. "Your Honor," Blake began, his voice smooth but carrying a current of intent, "the defense wishes to submit these records into evidence. They contain billing summaries, payment confirmations, and correspondence showing that the charges in question were consistent with the industry norms, and in fact known to the plaintiff at the time they were incurred." Emily felt a subtle jolt of alertness course through her. This was the moment she had anticipated, the attempt to bury her argument under a mountain of paperwork. She kept her face neutral, but her mind was already running through possible lines of attack. Mason gestured for him to continue, and Blake began flipping through the pages. "These documents," he said, "include email exchanges where the plaintiff's representatives acknowledge receiving invoices that reflect the rates my client charged. They did not object to those invoices at the time. In contract disputes, silence in the face of such charges can reasonably be interpreted as acceptance of the terms under which they were made." The implication was clear. Linda had, by failing to protest immediately, essentially agreed to the higher charges. Emily could feel her client shift uncomfortably beside her, and she knew the argument might resonate with anyone who saw inaction as tacit consent. When Blake finished, he stepped back with the faintest air of satisfaction, as though he had just placed a final stone in a wall that would be difficult to scale. Mason turned his gaze toward Emily. "Ms. Carter, your response." She rose slowly, taking a moment to organize her papers before stepping forward. "Your Honor, the defense's claim rests on a dangerous assumption that silence equals agreement. That is not the law. The contract before this court sets clear conditions for modifying its terms, and none of these documents satisfy that requirement. A failure to dispute an invoice immediately does not constitute a legal amendment to a signed agreement." She reached for the top document in Blake's stack, scanning it quickly before holding it up. This email, dated 3 months after the contract was signed, contains no explicit agreement to altered rates. It simply acknowledges receipt of an invoice. That is not acceptance, it is record-keeping. At no point does my client consent in writing to pay more than the rates in Schedule C. Her tone sharpened slightly, enough to cut through the quiet of the room. If we allow implied acceptance through silence to override explicit written terms, then contracts lose their purpose entirely. Businesses would be left vulnerable to after-the-fact changes that were never agreed to, and the predictability that contracts are meant to provide would be destroyed. Blake leaned forward at his table, ready to interject, but Mason raised a hand. "Mr. Blake, you'll have an opportunity to respond." His eyes returned to Emily. "Continue." She set the document down and selected another from the pile. "Here, the defense offers a billing summary with totals that exceed the contract rates by 15%. They claim this is consistent with industry norms, but industry norms do not override specific, agreed-upon rates, unless both parties have formally incorporated them into the contract. Without that, these summaries are irrelevant to the question of breach. They may describe what happened, but they do not justify it under the governing agreement." As she spoke, she noticed a ripple of reaction from the jury box. Small, subtle shifts in posture, a faint narrowing of eyes. It was enough to tell her that the contrast she was drawing between what was normal and what was legal was finding at least some traction. Blake eventually rose again, his voice carrying a slight edge. "Your Honor, the plaintiff's counsel is ignoring the practical realities of commercial transactions. Businesses operate in a world where adjustments are made on the fly. My client acted in good faith, charging rates consistent with what both sides understood, if not in writing, then in practice." Emily countered before Mason could speak. "And it is precisely that, if not in writing, that defines this breach. Understanding in practice cannot erase obligations in writing. The defendant had every opportunity to secure an amendment. They chose not to. The law does not reward that choice." The room felt suspended for a moment, as if everyone were waiting for the judge to signal which way the weight was leaning. Mason remained still, eyes shifting between them, his expression as impenetrable as it had been all day. But Emily sensed that the force of the defense's documentary assault had been blunted, at least for now. She returned to her seat, her pulse still elevated. The exchange had been fierce, the kind that could tip a case in one direction or the other, and though she had stood her ground, she knew the battle was far from won. In the silence that followed, the tension was at its sharpest point, balanced precariously on the edge of the judge's next decision. For several long seconds, the courtroom remained in absolute stillness, as if the air itself had been caught in a pause. Judge Mason's gaze lingered on the stack of documents Blake had presented, then shifted to the contract Emily had placed so deliberately before him earlier. His fingers tapped once on the bench, slow, deliberate, before he leaned forward. "Counsel," he said, his voice even but carrying an unmistakable weight. "This court has reviewed the contractual language in Section 12 and Schedule C, along with the evidence already admitted. I am compelled to note that the defense has not produced any signed amendments or modifications to the agreement in question." Emily's spine straightened, almost involuntarily. She had learned to read the subtle cues in a judge's tone, and this one suggested the ground might be tilting. Mason continued. "Furthermore, while the court initially excluded the invoice due to procedural deficiencies, the absence of that document does not negate the fact that the contract itself specifies the rates to be charged. Any deviation from those rates requires explicit written consent from both parties. The defense's argument that such deviations were understood or customary is unsupported by admissible evidence." Blake rose, his voice measured, but with a note of urgency. "Your Honor, with respect, the plaintiff is relying on a narrow reading of the contract that ignores the realities of the business relationship. We have shown that the plaintiff accepted the charges in practice." Mason's hand lifted, palm outward, silencing him. "What you have shown, Mr. Blake, is that invoices were sent and not formally disputed at the time. That is not the same as proving a valid contractual amendment. Silence is not consent when the governing document requires explicit agreement in writing." The words landed with the finality of a gavel strike, though Mason had not yet reached for it. Emily kept her face still, even as she felt a quiet surge of relief. This was not yet a ruling, but it was a public acknowledgement, one that undercut the foundation of Blake's argument in full view of the jury and gallery. Mason turned his attention back to Emily. "Ms. Carter, your reliance on the contractual clause is noted, and the court finds it to be a valid line of argument. I will give it full consideration in my deliberation." A murmur rippled through the gallery, quickly silenced by the bailiff's sharp glance. Blake, for the first time that day, shifted in his stance in a way that betrayed the faintest crack in his composure. He returned to his seat with movements that were precise but slower than before, as though recalculating his strategy in real time. Emily allowed herself one controlled breath, the kind meant to steady the heart without showing any outward sign of satisfaction. She knew better than to assume this moment would carry the entire case, but she also recognized its significance. For hours, Mason had seemed inclined to question and undercut her at every turn. Now he had openly affirmed the legitimacy of her central argument. She glanced briefly at Linda, whose eyes shone with a cautious hope. Emily gave a single small nod, a silent acknowledgement that they had just crossed a threshold neither of them could have predicted at the start of the day. The proceedings moved on, but the tone in the room had shifted. Blake's next series of questions to a witness felt more defensive than assertive, his cadence less fluid. Emily listened intently, ready to object at the slightest overreach, and twice Mason sustained her objections without hesitation. By the time the day's session neared its end, the balance between the two sides felt markedly different. Emily no longer sensed the same undercurrent of doubt directed at her from the bench. Instead, there was a certain attentiveness in Mason's demeanor when she spoke, as if he were considering her words on their merit rather than filtering them through skepticism. As the judge adjourned for the day, the sharp rap of the gavel echoed through the chamber. Emily gathered her papers slowly, giving herself a moment to process the day's turn. The reversal had been unexpected, but not accidental. It had come from hours of relentless focus, from refusing to abandon the contractual clause, even when it seemed an uphill battle. Walking out of the courtroom beside Linda, Emily felt the cool evening air hit her face, washing away the residual heat of the tense exchanges inside. She knew tomorrow would bring new challenges, but for the first time since the trial began, she felt that the path forward was not just possible, it was winnable. The next morning, the courtroom felt different. It wasn't just the crispness of the early light filtering through the tall windows, or the faint scent of freshly polished wood. It was the sense that something essential had shifted in the rhythm of the trial. Emily could feel it in the way people looked at her when she walked to the counsel's table, no longer with the speculative glances reserved for a young attorney on the edge of faltering, but with the quiet acknowledgement that she had earned her place in this fight. Linda sat beside her, her posture straighter than it had been in days. "You think he's already decided?" she asked softly, her voice low enough to be lost under the shuffle of papers and murmurs in the gallery. Emily shook her head. "I think he's listening now. That's what matters." When Judge Mason entered, the bailiff's call for order brought instant silence. He settled behind the bench, his expression as neutral as always, yet Emily thought she saw a certain precision in the way he organized the files before him. A sign, perhaps, that his mind was already turning toward final decisions. Blake made one last attempt to frame the case in his favor. Rising with his usual composure, he launched into a closing argument that leaned heavily on the idea of industry practice, mutual understanding, and the supposed flexibility of business agreements. He spoke of how commerce thrived on adaptability, and how rigid adherence to written terms could, in some situations, stifle fair dealings. Emily listened without interruption, pen poised over her notes, marking only the points she knew needed a direct rebuttal. She could see the calculated ease in Blake's delivery. He wanted the final memory of this trial to be one of sophistication and reasonableness, of his client as a pragmatic participant in a complex market rather than a corporate predator exploiting a small business. When it was her turn, she rose slowly, letting the silence between their arguments create a clean break. She carried the contract with her, holding it lightly but deliberately, as if to remind everyone in the room of its physical presence. "Your Honor," she began, her voice steady and clear, "the defense would have this court believe that adaptability justifies deviation from explicit signed agreements, but contracts exist precisely to prevent uncertainty. They are the anchor that ensures both parties know exactly what is expected and what is owed." She gestured towards Schedule C. "This document is not an abstract guideline. It is the product of negotiation, agreement, and consent. My client upheld her end of that bargain. The defendant did not. Instead, they charged more than the agreed rates, without any written modification, and now they ask this court to treat that overcharging as acceptable simply because it went unchallenged in the moment. That is not law. That is not fairness. That is a breach." She shifted her focus directly to Mason, her tone firm. "The evidence, what remains in the record, shows 3 facts beyond dispute. The contract contains clear rates. The The charges exceeded those rates, and there is no signed amendment allowing those increases. Everything else is distraction. Her words seemed to settle into the still air of the courtroom. Even the jurors who had heard variations of these points throughout the trial were leaning slightly forward now. Emily took a single step closer to the bench, not to invade the judge's space but to underscore her conclusion. This case is not about punishing a business for adapting to changing circumstances. It is about holding a party to the agreement they signed. When we allow unproven modifications to override written terms, we erode the very foundation of contractual law. The plaintiff asks this court to enforce the agreement as written and to award compensation for the overcharges that violated it. When she finished, she returned to her seat without another word, letting the weight of her final argument hang undiluted in the room. Linda's hand found hers under the table, a brief squeeze of silent gratitude. Mason's ruling came with the same measured tone he had used all trial, but his words left no ambiguity. The court finds in favor of the plaintiff, Linda Moore, and orders the defendant corporation to compensate the plaintiff for the overcharges in accordance with the contractual rates. The defense's reliance on implied modifications is unsupported by admissible evidence. The written agreement controls, and it has been breached. For a brief moment, the silence in the courtroom felt almost unreal, as though no one had quite processed what had just happened. Then the murmurs began, soft at first, growing as the gallery absorbed the decision. Blake's expression remained carefully neutral, but the rigid set of his jaw betrayed the loss. Linda turned to Emily, tears brimming in her eyes. "You did it," she whispered. Emily allowed herself the smallest of smiles. "We did it." The bailiff called for order once more, and Mason rose, leaving the bench with his usual unhurried pace. But as Emily gathered her papers, she knew this victory was more than just a line in her professional record. It was the culmination of every moment she had stood her ground against interruptions, objections, and the quiet doubt that had tried to take root inside her. The resolution was in motion, and it had carried her farther than she could have imagined when the case began. The courtroom was nearly empty when Emily finished packing her papers into her leather briefcase. The shuffle of departing footsteps had faded, leaving behind only the faint echo of voices in the hallway beyond the heavy oak doors. The scent of the polished wood lingered in the still air, mingled with the faint trace of coffee from a forgotten cup near the clerk's desk. Linda stood beside her, still clutching the folded copy of the judgment, her fingers brushing over the embossed court seal as if to confirm it was real. Emily paused for a moment, taking in the quiet. It was not the charged silence that had filled the courtroom during the trial, heavy with anticipation and tension. This was different. It was the kind of stillness that follows resolution, when the storm has passed and the dust has settled. She exhaled slowly, a deliberate release, as if she could let go of every interruption, every objection, and every doubt that had shadowed her over the past days. She was gathering her last file when she heard Judge Mason's voice from behind. "Ms. Carter." His tone was softer than she had ever heard it, absent of the clipped edges and precise cadence that had defined his courtroom demeanor. She turned to face him as he approached from the side door, his robe partially unbuttoned, revealing a glimpse of the man beneath the roll. He stopped a few paces away, his expression unreadable for a moment, before settling into something almost contemplative. "I may have been too quick to judge," he said plainly. "You argued that case with skill. You stayed on point when it mattered most. That's not something every attorney, young or otherwise, manages in this courtroom." Emily met his gaze, unsure whether to respond immediately. The compliment, understated as it was, carried more weight precisely because it came from him. "Thank you, Your Honor," she said finally, her voice steady but sincere. "I appreciate that." He gave a small nod. "Don't lose that focus. It will serve you well." Without waiting for further reply, he turned and continued down the corridor, his footsteps echoing briefly before fading entirely. Linda, who had watched the exchange in silence, stepped closer once the judge was gone. "I think that might be the closest he comes to admitting he was wrong," she said, her voice carrying a note of wonder. Emily smiled faintly. "Then I'll take it." They left the courthouse together, stepping into the crisp afternoon air. The city moved around them at its usual pace, people hurrying across intersections, buses rumbling down the street, the distant wail of a siren cutting briefly through the noise. To anyone else, it was just another day in Boston. But to Emily, it felt different, as though the streets themselves were somehow more open, more navigable than they had been that morning. As they walked, Linda glanced at her. "You know, I came here thinking the best I could hope for was a settlement that would barely cover the loss. I didn't think anyone could stand up to them in court. Not really. But you did." Emily looked ahead, the wind catching a loose strand of hair and brushing it across her cheek. "I did because you didn't give up. Every time I thought the case might slip away, I saw you sitting there, and I remembered why it mattered." They reached the corner where their paths would part. Linda toward the small shop she ran with her family, Emily toward the subway station that would take her back to her office. Linda extended her hand, but Emily shook it only briefly before pulling her into a quick, genuine embrace. "Thank you," Linda said, her voice catching slightly, "for everything." Emily watched her walk away before turning toward the station. She moved with the quiet confidence of someone who had faced down both an unyielding opponent and a skeptical judge, and emerged not only with a legal victory, but with a renewed belief in her own ability. The case had begun as a routine matter, at least on paper, but it had become something far more defining. Descending the station steps, she felt the low rumble of an approaching train. She boarded, found a seat near the window, and let the rhythm of the tracks steady her thoughts. Tomorrow there would be new cases, new challenges, perhaps new judges ready to test her resolve, but she would carry this day with her, the memory of standing her ground, the sound of Mason's understated acknowledgement, and the knowledge that respect, once earned the hard way, could not easily be taken back. It was in the end a quiet victory, but in the measured, unspoken language of the courtroom, it spoke louder than any applause.